Good morning, everyone, and welcome on the post-Easter Tuesday. My name is Jakub Jaraczewski, Research Coordinator at Democracy Reporting International, and I have a pleasure to welcome you to Justice Delight and Justice Denied, a webinar on non-implementation of European Court judgments and the rule of law, which also serves as the launch event for a joint report by European Implementation Network and Democracy Reporting International on the topic of non-implementation, non-compliance by the EU member states with decisions by the European Court of Human Rights and the Court of Justice of the European Union. This webinar is part of Reconstitution program, which DRI is carrying out with jointly with Forum Transregionale Studien on funding from Stiftung Mercator. And before I talked about the order of the day for today's webinar, I would like to introduce our fantastic panelists for today. We are being joined by George Stafford, Director of European Implementation Network and the primary brain and muscle behind our joint report. George has a long career of working with the European Court of Human Rights and its judgment, and has been leading the European Implementation Network for quite a few years, working on the topic of implementation and gathering data on what is the situation in European countries with regards to implementation of the decisions of the European Court of Human Rights. Then we have with us Ms. Sophia Veld, member of the European Parliament for the Renew party. Sophie is, I think, very well known to anyone who's been following the rule of law crisis in the European Union, because she has worked extensively on the topic, and as a part of the LIBE committee of the European Parliament, she's been active on various fronts when it comes to the rule of law situation in Hungary, Poland, but also other countries. And we are very thrilled to have Sophie with us today. Joining us also is Mr. Christophe Poirel, Director of the Council of Europe Human Rights Directorate, which deals with multiple topics, but among them, the implementation of the European Court of Human Rights judgments. And we're very happy to have Mr. Poirel with us to talk about the Council of Europe perspective on the implementation situation. And finally, joining us is Mr. Florian Geyer, the Head of Unit of Justice Policy and the Rule of Law at the European Commission, DG Just. And he, as his work in the European Commission, is dealing with the topic of compliance with the Court of Justice of the European Union judgments and how the situation looks on that side of the EU. And the way we're going to run today's webinar is going to be that I will first hand over the microphone in a few moments to George Stafford to talk about our report and our findings with regards to implementation of judgments of the European Court of Human Rights. And after George will be done, I will for a moment take away my moderator hat and put on a speaker hat and chime in with regards to how the situation looks concerning the Court of Justice of the European Union, and what are also some common findings that speak to both courts. And after that, we will ask our fantastic guests to provide their perspectives, looking at how the situation of implementation of and compliance with the decisions of those two top European courts looks from the perspective of their work in the European Parliament, in the Council of Europe and the European Commission, and what is the state of play with regards of looking into how do European Union member states tackle the issue of implementing the decisions of those two courts. Now, a few more information. We will be taking questions and we will be answering them after all our panelists are done. There is the Q&A function of Zoom, which you can use to convey your questions to us, and that would be probably ideal, but you can also type them in the chat. We will be moderating the questions. So unfortunately, we cannot guarantee you that we will be able to take up all the questions during the event, but we will try to pick up as many of those as we can. During the webinar, my colleagues will be sharing links. One of them will be linked to a survey where you will be able to give us your feedback on how the event went through and what are your assessment of our work. And also we will be sharing the link to our report, which is now available, where you will be able to find extensive information on the non-implementation of the European Court judgments and the rule of law. And without further ado, I'm going now to turn over the mic to our fantastic guests, starting with George Stafford, to talk about the report, our findings, what is the situation of implementation, or rather lack of it, by EU member states of decisions of the two top European courts. Take it away, George.
Jakub, thank you so much for your introduction, and I'm really grateful to the DRI team for organising this online event, and of course our distinguished panelists for joining us. I'm really grateful to you as well. So as Jakub mentioned, I'll be talking about the non-implementation of judgments of the European Court of Human Rights, and I'll begin by talking about the overall state of that issue and its relevance to the rule of law. I'll continue by discussing the methodology that we've used in our report, just a very broad overview of that, along with an overview of the results. And then I'll finish with 3 recommendations that we have contained in our report. So when it comes to the implementation of judgments of the European Court of Human Rights, I want to stress that this is a really significant issue and one that European actors should take very seriously. And our task in the report was to highlight the overall levels of non-implementation of these judgments across EU member states. So the following data which I'll provide concerns leading judgments. Now, leading judgments are those which have been classified by the Council of Europe as identifying a structural or systemic problem in a country. So these are judgments that come out of the European Court of Human Rights and really represent a human rights issue that hasn't been resolved by a state. So of the leading judgments from the European Court of Human Rights from the last 10 years concerning EU member states, 37.5% are still pending implementation. So overall, that amounts to 602 leading judgments from across the EU. And that's the total number, of course, pending beyond the 10 years. So each one of these 602 judgments represents a human rights problem that hasn't been resolved. So why is this a rule of law issue? Well, there's 2 main reasons I want to highlight today. One is to do with the nature of the judgments themselves. So, these judgments include violations about judicial independence, lack of judicial autonomy, freedom of expression, fair trial, issues that are really central to protecting the rule of law in states. Examples include judgments against Hungary and Poland regarding the independence of the judiciary there. And there's also 13 EU states at the time of reporting that had a leading judgment from the European Court of Human Rights pending implementation concerning freedom of expression. So these are fundamental issues about fundamental values across EU states that are really central to issues of not only the rule of law, but also democratic backsliding. So that's the first reason why it's a rule of law issue, the nature of the judgments. The second is really intrinsically the non-implementation of judgments being a rule of law issue. So, and of course, I won't have to explain this in too much detail to our distinguished panel and also the people attending this event, but court judgments are emblematic of a state that's run by the rule of law rather than the absolute power of the executive. And court rulings are really the operative tool by which courts keep the executive in check. And if governments exercise power without being held in check by the courts, then really the rule of law doesn't exist. So in terms of moving on to our methodology in the report, what we do is we go through the EU states country by country and presenting data on three issues. So one is the overall number of leading judgments of the European Court of Human Rights that are pending for each state. And as I mentioned, the total for EU states is 602. The second is another data point I mentioned, which is the percentage of leading judgments from the last 10 years, which are pending implementation. As I mentioned, also the average for the EU states is 37.5%. And then the third data point we highlight is the average time that leading judgments have been pending implementation. And the average time is 4 years and 4 months, which is really quite a considerable length of time. So what we do is we go through each state, we present the data on these 3 points for each of the states, and we provide a sort of analysis of the situation overall that these 3 figures lead us to conclude regarding the implementation of judgments of the European Court of Human Rights. It's important to say that the data is relevant and taken as of 1st of January 2022, so we don't take into account any developments that have happened since then. And we really think it's the best method that's been developed to assess the overall level of implementation in different states of the European Court of Human Rights judgments. And that's not to say that we think it's perfect, or that there can be issues with it that we'd like to receive feedback on and possibly develop our methodology in future. But nevertheless, we hope that it gives a really good overview of this issue and a really helpful tool by which others can use to assess this really important issue across European states. So in terms of the situation in different EU countries, I'm not going to discuss what we found in regard to each of the EU member states. But I will say that this is a problem that occurs across Europe. Non-implementation of judgments of the European Court of Human Rights is not isolated to just a few countries. So most EU states, the majority of EU states, have at least 10 leading judgments of the European Court of Human Rights pending implementation. There are a minority of states which have a very good record. The report highlights Luxembourg at the time the data was collected, having 0 leading judgments pending implementation. Other top implementers would be Estonia, Czech Republic, and Denmark. But as I mentioned, the majority of states do have an issue here, and countries like France, Germany, both have individual leading judgments pending implementation for over 5 years. However, there's 6 countries that we do highlight as particularly in need of improvement in this area. And each of those countries has over 30 leading judgments pending implementation. And those are Bulgaria, Greece, Hungary, Italy, Poland, and Romania. So finally, I want to finish with our 3 recommendations that come out of this report. And the top one, and the most important from our perspective, is that the EU Rule of Law Toolbox takes into account the non-implementation of judgments of the European Court of Human Rights in an overall way. And that's including in its EU Rule of Law reports, but also in the Justice Scoreboard. 2 subsidiary or secondary recommendations we have are that the Council of Europe activities in this area, so projects to help promote the implementation of judgments of the European Court of Human Rights, receive additional funding, including from the EU. And third and finally, that civil society activities across Europe are funded on this issue. So we're talking really about national organizations, major human rights organizations across EU states. They're keen to work on implementation of judgments and to promote this working from the grassroots up. But surveys indicate that they don't have the funding to do so. However, as I said, the main recommendation is about the EU's rule of law reporting. The non-implementation of judgments of the European Court of Human Rights is a distinct threat to the rule of law, and we hope that it can be taken into account in the reporting on this issue. That's all from me. Jakub, back to you.
Thank you very much, George, for this fantastic introduction of our report. And let me allow me to insert a few words about the Court of Justice of the European Union side of things. So the Court of Justice of the European Union has traditionally seen a high degree of compliance with its decisions. And that's been for several reasons, the 2 most important ones being first, that the EU member states are in general countries with a good and developed strong rule of law culture and a culture of compliance with decisions of judicial authority. But the second reason why the Court of Justice of the European Union has been highly complied with, especially in the cases arising from infringement procedures launched by the European Commission, is the ability to ultimately for the European Union to use financial sanctions against a member state which fails to comply with decisions of the Court of Justice of the European Union. And even furthermore, the ability to effectively collect those sanctions by deducing them from outstanding payments to EU member states, which is a very nifty mechanism for situations where an EU member state refuses to comply and to pay by themselves. However, also throughout the history of its activity, the Court of Justice of the European Union has seen many examples of non-compliance in various areas, not just the rule of law, competition policy, environmental policy. All of those were areas where member states would, at occasions, ignore, delay, or partially comply with decisions of the court. However, what we want to draw attention to today and in our report is that we are seeing recently a very dangerous trend of EU member states challenging the Court of Justice of the European Union, openly disregarding its decisions, and even going one step further than just failing to implement those rulings or interim orders, attacking the court, legally, of course. And just to highlight this trend as kind of kicked off with the German Constitutional Court in 2020 and its PSPPP decision, where it challenged the authority of the Court of Justice of the European Union. This matter, the whole case of the German Constitutional Court and the Court of Justice of the European Union disagreeing on the assessment of the European Central Bank's bond buying scheme, has been since resolved, and the kind of disagreeing parties have settled on a common understanding of the situation. However, this challenge brought by the German Constitutional Court has been, in a way, picked up, in a very dangerous way, picked up by other EU member states, primarily Poland. And here we are seeing a very dangerous situation. We are seeing an interim order of the Court of Justice of the European Union in a rule of law case concerning the disciplinary chamber of the Polish Supreme Court, the highly controversial body that is being used to harass and intimidate Polish judges, and an interim order in that case from the Court of Justice not being complied with. And we have, to my best knowledge at this point, passed the threshold of 150 million euro penalty for Poland for not complying with that interim order and with not halting the activities of the disciplinary chamber, which is an unprecedented massive amount of money. The penalty was set for 1 million euro daily, and since the 20th of November, Poland has not implemented this interim order. Making matters worse is the situation where EU member states, primarily Poland so far, have been using their own constitutional courts and top courts to attack the Court of Justice of the European Union, because in Poland, we not only are seeing a lack of compliance with decisions of the court, but we're also seeing government lodging cases with the Constitutional Tribunal, which has been compromised and has been politically taken over by the ruling party in Poland, and using that Constitutional Tribunal to, in a way, try to invalidate the decisions of the Court of Justice of the European Union, lodging cases which ostensibly are about compliance of the EU treaties with the Polish constitution, but are in fact an attempt to domestically review and provide the government with legal grounds to ignore the decisions of the Court of Justice of the European Union. And we believe that this is an extremely dangerous trend. And what we want to draw attention to is that we think the European Union, and in particular and the European Commission in the EU Rule of Law report, should be looking into the trend of disregarding the Court of Justice of the European Union. A wider trend, which, as we can see, also touches the European Court of Human Rights. This is not just about some governments ignoring one court. This is about some of those governments attacking the entire European legal order, both the EU law and the Council of Europe and the European Convention on Human Rights across the board. And this is something what is not just isolated data points, we believe, but this is a trend which is growing, unfortunately. We've seen very worrying statements, fortunately, not yet a decision, statements from the Romanian Constitutional Court earlier last year, speaking about how the decisions of the Court of Justice of the European Union cannot be implemented in Romania without a change of the constitution. So we believe that this is a trend, and a trend that needs to be addressed before it grows and before it begins to be picked up by governments and other EU member states and causing a very dangerous situation for the European Union's legal order. And with that, I'm going to now put back my moderator hat, and I am going to ask Ms. Sophia Veld, member of the European Parliament, to provide us with her perspective on the situation.
Okay, thank you very much. Thank you for the invitation and giving me the opportunity to share some thoughts on this topic, a topic that is very closely connected to two issues that I'm I've been pursuing for a number of years. One is the rule of law is the European Union as a community of law and how it functions, and as a kind of derivative from that, the issue of enforcement, and enforcement which is in decline, not just enforcement of court rulings, but enforcement more generally of EU law. I think we should conclude at least one thing, also having listened to both your introduction, is that the failure or the refusal to implement court rulings, implement them timely and completely and correctly, is undermining, is eroding the authority of courts, both courts, the Luxembourg and the Strasbourg court. I mean, that is happening. It's ongoing. It's just eating away at their authority. And sometimes you get the feeling that that people think that ECJ court rulings are, or ECHR court rulings are not binding court rulings, but sort of recommendations, non-binding, sort of pick and choose. And that is a very, very dangerous precedent. I think it's all the more serious as we see that the European Commission is relying more and more on what they call private enforcement of EU law, because the Commission has since Barroso I, as has been demonstrated by Daniel Kellerman and Tommaso Pavone, is increasingly abandoning its task as guardian of the treaties. It has traded in infringement proceedings as an instrument for enforcement, for dialogue, which is basically not yielding very impressive results. But more and more, we see that the European Commission says, well, if citizens are unhappy with implementation of EU law by member states, they can go to court. And they call this private enforcement. And of course, I mean, I wholeheartedly support the idea of European citizens taking ownership for enforcement, but it shouldn't be in place of the European Commission. It should be an addition to public enforcement. But the problem is there are a lot of citizens and NGOs and companies and what have you who are going to court. They elicit case law. It's a very cumbersome and very often also costly procedure, and then there is case law, and then the Commission says, well, great, we're not going to do anything with it. An example which I find particularly irritating is the so-called Koman ruling on the recognition of the rights of same-sex couples. There is a very clear court ruling which is being completely ignored by the member state governments. And then the Commission says, oh, well, if the member states are not implementing the court ruling, well, then the citizen has to go to court again. Whereas it is actually the task, the explicit task of the European Commission to ensure that member states are complying with their obligations. But the Commission itself is also ignoring case law systematically, in particular when it comes, for example, to the use of personal data in the context of law enforcement and security, and certainly when it comes to third countries. There is a court ruling on, it's a court opinion actually, on the exchange of passenger data with Canada. But of course, that ruling or that opinion applies one-on-one to similar agreements, in particular the one with the US. And we know that the agreement with the United States does not comply with European standards. That has been confirmed by that court opinion, and yet the Commission deliberately chooses to ignore it. It's again doing the same now with the successor, let's say, to Privacy Shield and Safe Harbor. Two, let's say, agreements, arrangements that have been struck down by the ECJ. And the Commission is again negotiating with the United States. They have recently announced that they have now the outlines of a new agreement. But we all know that it cannot be in line with the court rulings for the simple reason that the court rulings say that unless the US law is changed, that the United States cannot, they cannot be compliant. They cannot offer this adequate data protection. So the Commission itself is deliberately, knowingly, systematically ignoring case law. It's not just the Commission, it's also the Council. I think one interesting case is Access Info, where this NGO went to court because the, let's say, the Council minutes had systematically blacked out any references to individual countries so that it was impossible to know which country had taken what position. So the courts were very clear. It is not allowed to black out those references. So what does the Council do? They simply do not include the references anymore. I mean, that is clearly not in keeping with the spirit of that court ruling. You've already mentioned, Jacob, the fact that member states are increasingly and more openly challenging the primacy of the ECJ. I think that is an extremely slippery slope, and it's not just Poland. There is also a challenge by France, by the French government. And so far, it's not going as far as the Polish government. And the difference here with the Karlsruhe situation was that in Germany, at least the German government took a very clear stance and explicitly said, we recognize the primacy of EU law and we recognize the authority of the ECJ. But in the case of Poland and France, they don't even recognize the primacy of EU law, and they don't, even the French government is saying, well, in certain exceptional cases, we retain the right to not apply ECJ rulings because we consider that it's contrary to our national interests or something. So in conclusion, I think this development of case law being increasingly ignored by member state governments, as well as by the European Commission and the European Council, is incredibly dangerous, because it means that the whole fabric of the rule of law in Europe is coming apart. It's unraveling. And if we do not all, if we don't recognize the European Court of Justice and indeed the Strasbourg Court as the arbiters, the guardians of our treaties, of our laws, then those laws and those treaties become empty, because people cannot rely on them anymore. So it's extremely worrying what we see happening here, and I think we should ring the alarm bells very loudly and stop this trend.
Thank you very much, Ms. Veld, for the this perspective, and a look also from this situation seems from the perspective of someone who's working in the European Parliament and actively trying to bring up this issue. And now I would turn to Mr. Poirel for the perspective of the Council of Europe and how it is seen from Strasbourg. How the situation is seen from Strasbourg, working with the inside of the machinery of the Council of Europe, busy, among others, with the implementation of judgments.
Thank you very much, and good morning to all. And first of all, let me thank the Democracy Reporting International and the European Implementation Network, and congratulate them also for organizing this event on an issue that is central to the core values that we all share. Not only, I would say, rule of law. There is much insistence these days on the rule of law, but we should not forget the two other fundamental values that the two institutions share, namely human rights and democracy. I've listened with great interest to your overview, your presentation of the main conclusions and the main findings of your report. I must say that we in the Council of Europe have just issued also our annual report on the state of implementation of the judgments of the European Court of Human Rights. So for those who are interested, I would invite you also to go through our report, and I'm sure that the two complement each other. And in response to the initial point made by Mr. Stafford, be assured that we take the issue very seriously. There's no doubt about that. The implementation of the court judgments, and I would refer in my presentation only, of course, to the judgments of the European Court of Human Rights. The implementation of those judgments is essential for two reasons that perhaps it's good to recall. The first one is of course, to ensure the effective protection and enjoyment by all individuals living in Europe of the fundamental rights and freedoms which are enshrined in the European Convention of Human Rights. And the second, but that was mentioned already by Mrs. Veld, is to ensure the authority and credibility of our European Court of Human Rights and the monitoring system that is attached to the convention. Perhaps for those who are not familiar with the convention system, I should recall that states parties to the European Convention on Human Rights have voluntarily undertaken under Article 46 of the Convention to execute the judgments delivered by the European Court. So this is an international obligation, voluntarily, and I underline voluntarily, undertaken by states. And the Committee of Ministers, which of the Council of Europe, which supervises the execution of the court judgments, has repeatedly underlined the need to ensure the prompt, full, and effective implementation of the court judgments. This is the case, fortunately, for most judgments, but as you indicated when you presented some figures, George, about the non-implementation of court judgments by EU countries, there are unfortunately still quite a large number of cases where the judgments remain unexecuted, sometimes, as you said, for many years, including so in European Union member states. There are, and I think it's perhaps important to refer to that, there are different reasons for that situation. Basically, I think there are three reasons. The first one is and we must acknowledge that, the first one is the complexity and wide scope of the measures that need to be taken by states to implement the judgments. For example, if I take the case of judgments of the European Court of Human Rights regarding prison overcrowding or the excessive length of domestic court proceedings, obviously these are issues that require extensive measures to be taken by the states, and it's not an easy task always. The second reason for non-implementation is also sometimes the importance of the resources that need to be mobilized to execute the judgments. For example, in cases concerning the non-execution of domestic court decisions regarding debts owed by the states or public companies. And the third reason, which we all know, but which fortunately I would say applies only to a limited number of cases, is the lack of awareness and the lack of will at decision-making level, in particular regarding politically sensitive issues. The Committee of Ministers, which, as I said, is the monitoring organ of the European Convention of Human Rights, has, I must say, limited means at its disposal to secure the implementation of the court judgments. It can adopt decisions, it can adopt so-called interim resolutions, it can address invitations to either the chair of the committee or to the Secretary General or to member states even, to raise the issue of non-execution in their diplomatic and political contacts. And ultimately, in extreme situations, which has been used so far only twice, the committee may have recourse to the so-called infringement proceedings under Article 46.4 of the European Convention on Human Rights. So because of these limitations, the support that can be provided by other institutions to reinforce the messages of the Committee of Ministers and call on member states to execute the court judgments is very important and most useful. Inside the Council of Europe, this is done by a number of our institutions. I would refer, for example, to the reports and the resolutions that are adopted by our Parliamentary Assembly, or the statements that are made sometimes by our Commissioner for Human Rights. But I would also refer to what can be done outside the organization. And I think that the European Union as an institution which shares the same values as the Council of Europe can indeed play a most useful role in promoting execution, given its political influence and its powerful tools. In that respect, I would like to praise the European Commission, the Council, and the European Parliament for raising the issue of non-execution of major court judgments in their reports or in their decisions and resolutions. This is for us, I can tell you, very, very important, and we are very grateful. I would also refer to something which is perhaps less known, but also important for us, which are the statements and the contacts that are made by EU delegations at national level. And together with my colleagues in the execution department, we regularly visit our member states, and on this occasion, we meet the heads of the EU delegations in the member states, and we can see how committed they are to convey the same messages regarding our court judgments. And again, we are very grateful to them. So any political message action that can be taken by EU institutions is, in my opinion, a very powerful incentive for states to move forward. Beyond this political level, I think there is also room for joint action at the technical level. The Council of Europe carries out activities to assist member states in implementing their judgments. We are not just there to say to our member states, the court has delivered the judgment, and now you need to implement the judgment. No, our duty is also to help our member states, given the difficulties that I mentioned before. We do so bilaterally through informal expert assessments, for example, of a draft laws prepared to execute the judgments of our courts, or through the organization of a training and awareness raising activities involving different national stakeholders, where in particular, I would say there is a need for a comprehensive national strategy to be put in place. We do so also through what we call regional activities, bringing together representatives of different states where they can share their experience, but also the best practices that may exist in some countries. In my opinion, more can and should be done in terms of assistance. So I know the focus is very much about the political leverage, but sometimes we overlook a bit the technical leverage, which is also very important for our member states. But that requires, of course, substantial financial and human resources, which go, I must say, unfortunately, beyond those available at present within the Council of Europe. And following the 3 recommendations that were made at the beginning by George Stafford, I would refer to them, especially the last 2 ones, because I addressed already the first one about the EU rule of law toolbox, taking into account the judgments that I think I've covered already. But when it comes to your second and third recommendation, I would entirely concur with them. And I think that's in particular for the technical level, the technical assistance that can be given to member states. I think that is an area where pooling resources between the 2 institutions may be useful. We have already so-called joint projects between the Council of Europe and the European Union to support reforms, including for the implementation of court judgments in non-EU member states. But I think that there is no reason to limit those projects to non-EU member states. I've been advocating that for many years now. I think that similar projects could and should be considered even for EU member states, either at the bilateral level or at the multilateral level when they face similar issues. This avenue could be explored, having also regard, I must say, to the work carried out by DG Reform, with whom we already work in some EU countries. So I think there is probably scope for increased synergies between the European Union, the European Commission, and the Council of Europe through the projects that are organized and implemented by DG Reform. And finally, on your third point, George, about support for NGOs, I would agree with that point. I think clearly, I don't know how it is for the judgment of the European Court of Justice, but for the judgments of the European Court of Human Rights, the Committee of Ministers and my colleagues and I, who assist the committee, we rely heavily on so-called written submissions that we receive from national human rights institutions and NGOs. The supervision process is driven through the submission of so-called action plans and action reports by the member states. But it's very important for us that in addition to those action plans and action reports, we get also the views of civil society as to the way in which the judgments are implemented, whether there is any progress, whether there are any shortcomings that remain. And that's where those written submissions are very important. I must say, we have organized, but to a limited extent, given our limited resources, we have organized in the past training activities for national human rights institutions, for example, on how to submit written submissions, but our plan is to do more. We have also put in place a dedicated web page on our website where national human rights institutions can go and find information about the execution process, because to get timely written submissions, of course, the NGOs and national human rights institutions need to know where we are with the supervision of the execution of the judgment. So the third point that you mentioned, as I say, support for NGOs for me is also very, very important. Sorry if I've been very long, and thank you again for the invitation.
Thank you very much, Mr. Poirel, for this extensive elaboration on the Council of Europe side of things. And I think it's very important that we remember about all the various interfaces and collaborations between Council of Europe and the European Union. I've been personally involved in researching the joint programs in the past, so I'm always very happy to hear about them going on and continuing. And now, before I turn over the microphone to Mr. Florian Geyer to provide the insight from the European Commission, I've been just made aware that the disciplinary chamber of the Polish Supreme Court will be holding a hearing tomorrow in the case of one Polish judge with a view towards suspending them perhaps from the job. And this is the disciplinary chamber which has been subject both by decisions of the Court of Justice of the European Union and the European Court of Human Rights, and has its continued activity is the source of the 150 million euro penalty that Poland has been aware of. It's a reminder that while we're discussing, these things are unraveling in real time, I would say. And with that kind of introduction, Mr. Geyer, we would be very happy to hear your perspective and the view from the European Commission's insight on the implementation issues.
Thank you so much. Thank you everyone for the opportunity to be part today also of this launch event of the very important report of EIN and DRI. You mentioned, Jakub, you made reference to the current activities and I think the current developments, and I think we could, in the link of speaking between the different courts, we could also mention the role that the European Court of Human Rights is playing in the context of the Polish situation that we saw. I think just last week, the court issued interim measures, again, in a concrete case, trying to protect a judge, that is subject to the ongoing disciplinary proceedings, and I think there, especially on this case, on this situation in Poland, how the different courts, how the different actors come together, trying to uphold, the rule of law, the fundamental rights of the judges concerned. But we also see, what struggle it is, and you mentioned the enforcement measures that amount indeed to several hundred millions, more than 100 million euros. And I can come back to that in more detail later. But before going into individual cases, also to make the reference to the report that mentions how this issue is becoming more and more relevant, how it's becoming more and more at the center of attention also of citizens over the last years. The labeling of backsliding as has become now a standing terminology. I think that is something that hasn't existed couple of years ago, and today not only we have the launch event of your report, but then in the next 3 days there will be, I think, the final conference of the major Reconnect, the program, which is, I think, is also brings together everybody around the table who has been working on these issues, looking at all the 3 dimensions: rule of law, democracy, fundamental rights, because we need to see them in their trias together and how they reinforce each other, but how also they can be under threat at the same time. And then, of course, also making reference to the current debates, and I think we should not forget the Conference on the Future of Europe, where also several recommendations have been brought forward on the different issues and on rule of law. There are at least 2 which are feeding into this process. So I think that's also something that we see as part of the wider picture. Now, the recommendations, the report and the recommendations that are being launched today, they are of direct relevance to the work of the Commission, and in fact, most of the recommendations are addressed, as you can see, to the Commission. Although they relate to the enforcement of the European Court of Human Rights judgment, and Christophe Poirel has set out the mechanisms on their side, but of course they are interlinked and they go hand in hand. So that is, we are very grateful for the recommendations and for the report. Before I go further, I need to say, and you all know this, that whatever I say is not binding the Commission. I'm expressing my personal views. I need to say this, and it's nothing dramatic, but just to recognize this. What I try to say, what I try to pick up on in the introductory part of my intervention are three points, and they are related to the recommendations. The first one is how we, at this stage already, try to take into account in the rule of law report the issue of the implementation of the European Court of Human Rights judgments. The second point is how the Commission, I think this is, Jakub, what you wanted me mainly to talk about, but I will try to keep it short also, is how the Commission, what about the Court of Justice's judgments and how we monitor the implementation there. And then maybe a last point, and that picks up on the specific challenges, on maybe the effectiveness challenges, but also the primacy challenges that we have recently seen, which is also part of the report, and a very important feature that you mentioned in the beginning of your intervention. Good. So on how we take into account the implementation of the Court of Human Rights judgments in the rule of law report. At this stage, you will see, and the report refers to that, that in the existing country chapters of the rule of law report, we already cover certain judgments of the European Court of Human Rights. Also, Christophe made reference to this, that this is an important echoing room for the Court of Human Rights judgments. But these are at the moment mainly those judgments where there is an enhanced supervision by the Committee of Ministers, and mainly relating to the areas of systematic challenges like the functioning of the justice system, or excessive length of proceedings, or the absence of a compensation scheme. So these directly related issues, which then fall in the logic of the rule of law report under pillar 1, where we speak about the justice systems of the member states. This is where we report on them. And then, of course, key judgments which play a crucial role, like, as we mentioned before, the Constitutional Tribunal, the situation of the Constitutional Tribunal in Poland or in other member states. And then under what we call the 4th pillar of the rule of law report, which is more about how the state authorities deal with such challenges. We also cover some of the judgments there, how the judgments were implemented. But of course, the data and the findings of the report, as you present them now, are particularly interesting in the sense how they show, independent of what is inside the judgment and the content of the judgments, what does it show about the respect for the rule of law and the respect for the judgments if the judgments remain unimplemented for such a long time. So in this respect, and we have been also in contact before, we are indeed looking into how to reflect this in future editions, this issue of, what does it say? What does it give as a message if member states fail to implement? And as we were in good contact before that, and we are very grateful for the opportunities that we had in discussing about this together. And as I said, we are looking into this for the 3rd edition to see if there could be a hook where we could anchor this. So we're actively looking into this to respond to your first recommendation. And it becomes interesting also to see, like in which extent there would be a coherence, a congruity between the findings of the report and those member states on which, under the rule of law report, maybe the more serious concerns are expressed, and to which extent they might, go together, overlap, to give this kind of the more systematic picture and the opportunity to also then focus on the issues which are most important. Of course, what we also need to be aware of, the mere numbers of leading judgments and their implementation and the years is one indicator, but it might not only be the only one. And there we come to what you also said before, Jakub, and also Christophe and George. If you look only at the numbers, Poland as a member state is not doing as bad as others in terms of implementation. But we know that there are around 100 cases pending related to the Polish justice system in Strasbourg, and that is not reflected in the figures. So we need to combine, I think, the qualitative and the quantitative in order then to create and to find the right messages and what it means. Because of course, the cases that pend and that are related to the justice system in Poland are Article 6 cases, where Article 47 of the Charter is our equivalent. And you could argue that if Article 6 doesn't work, if Article 47 of the Charter doesn't work, nothing works, because you need the effective courts, you need the judicial independence to render all the other rights effective and to have the place to go to enforce your rights. And that's, you know, like the issue that I wanted to say about the quality and the quantity and the numbers, and then to look into what are the topics that are actually addressed and to which extent are this a systematic problem or they are just a non-implementation problem of one case. But that's also why, of course, if it's leading judgments, we have already the indication that they are either very serious or they have the systematic dimension. Now, coming to the second point on the implementation of our own judgment, if you want to say, the Cju judgments, the report says that unlike the situation of the European Court of Human Rights, the implementation of the Cju judgments are not tracked at the level that would allow such a quantitative analysis as you have like so well done for the European Court of Human Rights judgments. But here, maybe it's not as visible, but of course, what we want to say is that each of the infringement proceedings that are being launched, they are fully tracked, because it's the college that opens an infringement and it's the college that closes an infringement. So each department in the Commission responsible for an infringement, you know, like has to keep track all the time and has to come at one stage to a conclusion to either say, okay, the issue is addressed and we close the infringement, or the issue is not addressed and we need to look into other means of enforcing it. And then, of course, as you said, the possibility of asking for financial penalties for the non-enforcement. But each of the cases is keeping tracked. And what we try to do with the database, you know, there's the infringement database where normally each of the steps can be traced. At which stage in the procedure are we? Is it still open? Is it closed? Letter of formal notice, recent opinion, which states have we achieved? So this should be one opportunity to be able to go into the tracking. And the other opportunity, of course, that's the annual report on the implementation and the enforcement of EU law that goes across the Commission on all the departments, you know, and as you said, the non-implementation cases, in environmental cases, in state aid cases, which have you picked up as the ones where you saw the most reluctance by member states to implement them, either because they involve, you know, like a lot of effort to amend, or they want to protect a certain group in society against, you know, like what the impact of EU law, and you have identified these areas of policies which seem to be particularly relevant for the non-implementation. We are working on our side. You know, in my department, we have, you know, we work on the rule of law, we work on the Polish cases, we work on primacy aspects, and I think in those areas, enforcement has been happening, and you made reference to that also before, notably also since the last July, in a way maybe that we have not seen before, also by asking interim measures, by enforcing interim measures, by asking, you know, like by getting the green light to continue with the financial penalties enforcement on the disciplinary chamber rulings. And all this is laid down, and that's the last part. How do we deal with those challenges of enforcement? How do we deal with the primacy challenges? And In the communication, that will be the last 2 minutes that I need to take, and then I will close. In the last existing communication, where the Commission tries to set out its policy on enforcement, and that's the communication from 2016. It's a bit outdated, but the principle on these areas that I'm talking about are still relevant, where the Commission promised to pay particular attention to those cases where national rules would impede the application of union law, where it would impede national courts from applying EU law, or where, and that's what we have seen recently more and more, where there would be a system that would make it, where they would discourage or make it impossible for national courts to actually ask for preliminary references, because that is, of course, the crucial dimension where the dialogue between the courts need to take place, and that is within the procedure of preliminary references. And if you have systems in place that would, either threaten judges with disciplinary measures if they would dare to ask a preliminary reference, or where higher instances could overrule lower courts when they would ask a reference for preliminary ruling, or where the prosecutor general would get the right to challenge a national court's decision who asks for preliminary reference, to bring that to a higher level. These are all, again, systematic cases where in the end it is about the effective enforcement of union law. It's about Article 47 as far as fundamental rights would be concerned, where you have the role of the courts, the national courts that have their assigned role also under Article 19 of the treaty to play their role. And if this is made impossible by the national system, this is where the Commission needs to come in, when we try to play our role and come in as much as we can. And then, of course, you have seen the primacy challenges that you referred to. I don't need to repeat the line of the Commission on the prospect of primacy, but it is, as you say, it is more and more challenged. It can no longer be taken for granted anymore. We have the cases that you mentioned in Poland, in Germany, where infringement procedures have been launched. MEP Infeld also referenced the other member states, where there are concerns. And we have recently seen also in the context of preliminary ruling cases, Grossmania on the 10th of March, the case RS on 22nd of February, the Eurobox judgment just before Christmas, where very concrete primacy questions come into place. And these go beyond, the member states that we have mentioned so far. So it is becoming a more and more virulent issue that needs tackling, and that we are committed to tackle in line with the guidance and the communication that I mentioned before. I think I leave it here, not to speak too long, and thank you very much again, and thanks a lot for the report and for the debate today.
Thank you very much for this elaboration, and I am very happy to see questions popping in from our attendees. And I think I will begin with a question which has been presented by Professor Murray Hunt from the Bingham Center for the Rule of Law. And the question speaks to another commission that it has a role to play when it comes to implementation of judgments of the courts, which namely is the Venice Commission. And the question is in the view of the lack of resources to provide technical assistance in implementation of judgments, could there be a greater role for the Venice Commission to use its considerable expertise to assist EU member states in their implementation process? And I think since we speak to, yes, Mr. Poirel, because this is speaking to Venice Commission, I think I will throw this question at you and see what's your insight, but often, of course, other panelists will be invited to chime in as well.
Yes, thank you very much. I must say it's a very good and very relevant question, but I must say the Venice Commission is already heavily involved in a way in the implementation of the court judgments whenever the Venice Commission is requested to give an opinion. It refers, where this is relevant, of course, to the judgments of the court, and also by making assessments, it makes certain recommendations that are used thereafter by the Committee of Ministers when the Committee of Ministers reviews the implementation of the court judgments. for instance, on cases concerning the independence of a superior councils of magistrates and prosecutors. We had in the past a number of opinions of the Venice Commission on how to secure this independence of those bodies, and that is mentioned quite often, I would say, in the decisions of the Committee of Ministers. So already now we use very much the opinions and the recommendations of the Venice Commission. But the role of the Venice Commission is only an advisory role. It is not there to implement so-called technical assistance activities. And one cannot go without the other. Advice needs to be complemented by practical assistance to implement the advice. And that's where we need more resources, as I said before. I hope I've answered the question.
Thank you very much. I can see Ms. Veld has risen her hand.
Yes, thank you. Well, first of all, to this question, you know, I'm sure that there are cases where the non-implementation is the result of lack of capacity, lack of expertise, what have you. But I think in many cases it's actually lack of political will, and we can come up with 1,000 solutions, but you cannot find a solution against the lack of political will. In this respect, I'd be very interested to hear Mr. Geyer also comment on the issue of the European Commission actually, I mean, not downright refusing to apply a case law, but to basically duck it, twist it around, ignore the, let's say, the spirit of the rulings, and basically trying itself to ignore what the European Court of Justice has said. Then two things for information. First, it was suggested that the annual report should include an overview of the rulings and their implementation. And we've actually proposed an amendment to the European Parliament report to the annual report on the rule of law, saying exactly that we call for the inclusion of an overview of all enforcement actions, blah, 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 as well as the state of compliance with provisional measures and rulings of the Court of Justice of the European Union and the European Court of Human Rights. So we've already proposed that. We are also working on, because this Mr. Poirel mentioned NGOs, a couple of years ago, I think it was 2017, an amendment that I put forward was adopted by Parliament calling for a litigation fund to be included in the European Union budget. The Commission has fiercely resisted that. Eventually, the amount that had been foreseen has been included in another fund where it can also be used for the costs of litigation. But we are going to take a new initiative for the creation for such a fund, because if the Commission is increasingly leaving enforcement litigation, strategic litigation to private actors, then they should also have access to, to the means to litigate. So, and one final remark also to Mr. Geyer, because you said that well-functioning and independent courts are crucial to safeguard all the other values and laws and what have you, and I couldn't agree more. And that is why I'm so surprised that the European Commission is still negotiating, or I don't know exactly what's happening, but Mrs. von der Leyen seems to be concluding some sort of deal with the Polish government, whereby I imagine she's saying, well, okay, you can destroy the rule of law a little bit, but not too much. And then, if you promise to behave, then we'll disburse the recovery money, which is 36 million or billion euros. So, and I mean, I entirely recognize that she is in charge of that decision and that you are actually making every effort to secure the rule of law. But I'd like to hear your comment on that as well.
Thank you very much. And I guess I'm going to hand over the mic for Mr. Geyer for a second now.
Thank you. That's very kind of you. Ms. Infeld, you had the opportunity to ask directly the president on this question in the question time on the RRP, and she replied that that was before the event on the 9th of April, where said she's not going to Poland to hand over on the 9th of April the RRP, the positive assessment of the RRP. That is, of course, it is a very big question, and the negotiations are ongoing. I think it's important to look at this from all the sides, and Jakub will know very well what we have also noticed last week is that the National Council of the Judiciary, the Polish National Council of the Judiciary, issued an opinion and said that if the Duda law, if you want to call it, so the president's proposal, the Polish president's proposal of the how to reform the Supreme Court, would be formed in any way as part of a new law, the National Council of the Judiciary would bring this law to the Constitutional Tribunal to have the unconstitutionality of that law that, as you know very well, is part of this negotiation between the Commission and the Polish authorities, checked by the Constitutional Tribunal. And we have seen recent rulings and the outcome of the Constitutional Tribunal. What that means, of course, would be speculation, but I think it shows that it's also very, how to say, it is also on the national side in Poland still very unclear what is actually the law that is being negotiated that could be part of a positive assessment of a possible recovery and resilience plan. But you also rightly point out, and there I have to fully, and I'm grateful that you see that. Myself, I'm not in the center of this, and it's a decision that is, of course, at the top political level that is being discussed, and you all know also the wider context of this. But it is, of course, at this stage, the negotiations have not concluded, and there is no positive assessment, neither for the Polish nor for the Hungarian plan, because the issue remains. And on your question, sorry, Sophie. On your question also about, what do I say about the Commission's deliberate non-implementation of certain preliminary rulings or of certain judgments? Again, what I can say is that from where I'm sitting and what I'm doing and what my team is doing, we try to work on the enforcement, and we try to work on the parts that we are in charge of. That also is, a lot of convincing that we need to do on all the sides. I'm of course aware of the cases that you refer to. I would not call that this is a deliberate, deliberate choice to not comply with the rulings. I think there are reasons why this is not being done in the way that you criticize and that you pick up. But I think for the area, and that also goes for justice in the wider sense, also under Commissioner Reinders, I think the enforcement action on the parts that also, as you know, like the old third pillar acts that have never been enforced even after the Lisbon Treaty entered into force, and where we had the opportunity under the previous Commission to do it. The choice was not to do it, but all of this is now being tackled in a much more strategic way than it was before. Also, enforcement action on the framework decision on criminal laws for racism and xenophobia, things that had never been touched before because they were considered to be too politically sensitive, are now being tackled. So I think in the area that I'm speaking, there is an enforcement drive and infringement drive that is also thanks to the Commissioner that we have, and this is of course something that we particularly welcome, that we have this opportunity and that we are able to increase actually the numbers. And that was also referring to the study of Kellerman and Petone that you mentioned. Maybe overall the numbers have decreased, but I think in our area of competence and the areas where we work, we have actually increased the numbers as compared to the previous Commission. That's also what Emmanuel said when he was speaking about the study in the group that you lead, Ms. Infeld. But again, also the question of the quality, which are the cases that we try to tackle, and which where do the numbers maybe not give the full picture. But it is an interesting and important debate, yeah, I think I leave it here again, not to occupy the speaking time. Thank you.
Thank you very much. And the next question I have is a very particular question considering our report, which I'm going to hand over to you, George. And that's a question whether there is any particular reason that our report does not mention that in many cases the individual measures have been implemented, where cases are still pending on general measures. And this is highlighted as an example with case regarding to Finland and likely also many other states as well. George, if you could speak a few words on this.
Sure, I'm very happy to respond to this. For those who are watching who don't know the distinction between individual measures and general measures, individual measures are the steps needed to be taken to implement a judgment of the European Court of Human Rights as regards the individual applicant. So it's often things like payment of compensation or measures to have a retrial or something like that. Whilst general measures are the steps needed to take to implement the judgment in regard to society as a whole, to make sure that the same problem doesn't happen again. So our report does indeed focus on the implementation of leading judgments, which normally revolves around general measures. And it's true that we don't talk about the implementation of individual measures. And the reason for that is very straightforward, is that because we wanted to highlight the structural nature of this problem and the structural levels of issues all across Europe regarding the implementation of judgments. And it's sometimes and often perhaps used by states. The idea of talking about individual measures is very good and it's very important, and it's an essential part of the implementation of judgments of the European Court of Human Rights. But it's sometimes used as a way to divert attention away from general measures, to say, well, we've paid lots of compensation, or we've taken steps to resolve the problem in this one individual case. But the real point of the system, the ECHR system, is to provide justice not only to the individuals who are committed enough, energetic enough, or perhaps fortunate enough to bring their case to the European Court of Human Rights, but to protect the rights of obviously all Europeans. And that's the thing we wanted to bring attention to. And we didn't want to distract attention with more discussion of individual measures, when we think that the leading judgments and the general measures are not receiving sufficient attention.
Thanks, George. And just to piggyback on your explanation and to give an example, the Polish government has elaborated that it will implement the individual part of the European Court of Human Rights judgment in the Xeroflor case concerning the status of judges of the Constitutional Tribunal, and it will pay out the compensation. I think it's 3,000 and 4,000 euro to the applicant, but it will explicitly refuse to implement the general part and to look into the issue of the status of judges of the Polish Constitutional Tribunal, because, as the Polish government has elaborated, there has been a judgment from the very same Constitutional Tribunal saying that the Article 6 right to fair trial cannot be interpreted in a way that allows the European Court of Human Rights to look into the status of the judges of Constitutional Tribunal. So we have the implementation on the individual measure, which is arguably good, but we have a very worrying development on the general part, which is an example of how this pretty much goes down. And the next question from Prof. Carol Lyons from the Aberdeen University is a fascinating one, and it is the question of what impact will or might have the European Union's accession to the European Convention on Human Rights on the implementation issue. As we know, the process of negotiation between the both organizations is ongoing with relation to a second attempt to hopefully have the European Union accede to the European Convention of Human Rights. And I'm very curious if any of our speakers have some reflections on how could possibly European Union ratifying the European Convention on Human Rights have an impact on the implementation issue.
Well, if I may, perhaps to start, I would say that EU accession to the ECHR may have two kinds of impact, if I may say so. One is that cases concerning alleged violations of human rights by the EU would be referred then to our court in Strasbourg, and that would and the court would examine those cases the same way it does for the national cases that it receives, and that. So the first impact would be that the court would deliver judgments with regard to the decisions or non-decisions taken by the European Union. And the second impact is a more procedural impact, which is that by acceding to the convention, the EU would become also a party to the mechanism, the supervisory mechanism within the Committee of Ministers. So the EU would be entitled to appoint a judge first within the court, but thereafter, when it comes to the supervision of the execution of the court judgments, the EU would be also taking part in the meetings of the Committee of Ministers, where the committee reviews the state of implementation of the judgments. And we have also an ongoing discussion within the working group that we have, the so-called 46+1 working group that we have in Strasbourg, on how to accommodate, I would say, this participation of the EU with the fact that we work in a forum that is broader than the member states of the European Union, which involves also non-EU member states. And there is the legitimate expectation, I would say, on the side of the non-EU member states to make sure that the EU could not, in a way, dominate the decision-making process within the Committee of Ministers, because normally the decisions by the committee are taken by consensus. But it may happen that they are also taken by a vote, and there is a qualified majority, which is basically 24 out of a 46, which means that in principle, with 27 member states, the EU could dominate the decision-making process within the Committee of Ministers. So, as I said, there are discussions that are going on in order to accommodate this potential dominating role of the EU with the concern of the non-EU member states to make sure that every state, I would say, is treated equally. So from my perspective, this would be the two main impacts. But the first one, of course, is the most important one in terms of content.
Thank you very much, Mr. Geyer. Please feel free to.
Yeah, just to complement, I think that the interesting part also is not only would then, the Union be part of the mechanism on the supervision, but actually, as you also said, Director Poirel, it would mean that the non-implementation by the Union of judgments that were rendered against it would be part of this debate too. So actually, then George could include a new section in future editions of the report, where also the EU as an entity and as its a member in its own right will have to prove how we implement the judgments that will be in the future rendered against EU acts or non-acts, legislation, individual decisions, everything that will be subject to the control by the Court of Human Rights. So is going to be a very important dimension as well, and that's also why I think it's important, also as mentioned before, to see the alignment also between the two courts in terms of referring vice versa to their jurisprudence and taking up the jurisprudence of the courts in interpreting similar provisions, same provisions in the same way, and this reinforcing character of the case law of the two courts is very important. And now again, coming to our very concrete work, the judgments of the Court of Human Rights in the issues like, for example, the Polish situation are extremely important for us in also bringing cases forward under the EU context, given simply the high number and the possibility of having the direct access to the protection system in Strasbourg. And as I said, I think we have over 90 cases, and each of these cases, will lead to judgments or interim measures. And that is also a non-negligible fact that, on the other hand, reinforces our work again to say and to make the case on how to deal with the situation and how to address it. So I think this reinforcing character cannot be underestimated, and even this is before accession. So after accession, this will be even stronger. That's what I wanted to contribute. Thank you.
Thank you very much. One question which makes me miss the fact that we don't have any judges of either court is the question on the possibility of the Court of Justice of the European Union and the European Court of Human Rights considering some sort of joint opinion on the emerging problems of implementation, and is that even possible? And maybe I will start speaking with that. So far, both courts have been conducting primarily dialogue through their decisions and rulings, where they would refer to each other and bring up each other's case law, sometimes agreeing, sometimes disagreeing. But the idea of both courts speaking jointly to one topic, even if in a kind of a soft way, not through, of course, some kind of joint judicial decision, because there was no legal grounds for that, but perhaps through some soft elaboration, is quite tantalizing, I would say, and especially also in the context of what Mr. Geyer reminded, that we're looking increasingly at converging problems of, say, the right to fair trial, as seen in Article 6 European Convention and Article 47 on the Charter of Fundamental Rights. I was curious if any of our panelists have any reflections on the possibility of the both courts addressing the issue jointly in some way.
If I may, I would say as such, it's an interesting idea, and ideally, it might be good on some occasions to have joint opinions, but I'm afraid, legally speaking, this is not possible at this stage. So our courts would not be able to issue a formal opinion together with any other court, not only the European Court of Justice. So that is not possible. But to follow on what Florian said before about the dialogue between the courts, and this is indeed a very important point. And beyond the more formal steps that may be taken, what is important, in my opinion, is the informal contacts that exist between the two courts to share their opinions, their assessments, their evaluations. It's a concrete way, which is less visible, of course, but it's a concrete way to approximate, I would say, the approach of the two courts. But beyond that, I'm afraid having formal joint opinions would not be legally possible.
Thank you very much, and that would be my assessment. That would be my assessment as well. Although the idea of both courts converging on the same issue, even if that's separately to their case law, is very much something to watch out for. We're getting close to the end of our. We're getting very close to the end of our allotted time. So I am going to pick one more question, and unfortunately for all the other attendees, I'm very sorry, but. The time constraints are unfortunately very strict, and we hope we will be able to answer your questions in some other way. However, there is one question which also has been on my mind, and a question which shows that whatever we try to do in any discussion on the rule of law in Europe, we cannot escape the situation of the war in Ukraine and the Russian attack. And the question is about whether the removal of Russia from Council of Europe, as it was ejected, and as currently the Council of Europe is dealing in many consequences in the fallout of Russia's removal. Does it provide something what P.S. Gardner describes as his question as a once-in-a-lifetime opportunity for the to park the quarter of caseload, the cases concerning Russia at the European Court of Human Rights, and to catch up with all the other pending judgments which are already swamping the system, and to catch up with all the other outstanding items that have been eclipsed by the sheer amount of case law ongoing concerning Russia? And this question, I believe, both for George and Christophe, but also other panelists, feel free to chime in on what could be the impact on the implementation of the fact that Russia is no longer a Council of Europe member state.
Well, I think there are two points in your question. The first one is about what about the cases that are pending before the court as such. And as you know, Russia will remain a party to the convention until the 16th of September this year. So the court may continue to receive new applications until that date, and thereafter, what the court will do with all these cases that are pending before it, that is a matter for the court itself. So I'm afraid I can't say much on that. But I know that there are discussions going on within the court as to what should be done. That is the first aspect. The second aspect is about the implementation of the cases concerning Russia, which are now pending before the Committee of Ministers, and we have quite a high number of pending cases regarding the Russian Federation. There, for the moment, we continue to monitor the implementation of those judgments. So we we had a number of Russian cases at the last meeting of the Committee of Ministers last month. We will have again some Russian cases on the agenda of the Committee of Ministers in June. But then the question will be after September, what will happen? And we hope that the Committee of Ministers will have a discussion at that point at its June meeting to decide what to do regarding those cases that are pending regarding the Russian Federation after September. The difficulty, I must say, in practical terms is that although the Russian Federation can participate in the meeting of the Committee of Ministers to provide and receive information without having the right to vote or without having the right to take part in the decision-making process. Although there is this possibility, unfortunately, the Russian delegation was not present at the last meeting of the Committee of Ministers in March. And therefore, of course, for the Committee of Ministers, it's very difficult to discuss the implementation of the judgment without the respondent state being present in the meeting rooms. That's the difficulty we are facing now. I suppose we will face against this difficulty at the next meeting of the committee in June. And I suppose that it's also in the light of that limitation that the committee will decide later what to do with the pending cases concerning Russia. But formally speaking, they remain on the agenda of the Committee of Ministers.
Thank you very much for this insight. George, do you have anything to add onto that?
I don't really have too much to add, Jakub. I think, as Mr. Poirel has already noted, there's a huge amount of uncertainty about exactly what's going to happen in regard to Russia. I'll speak only about the implementation of judgments, and as Mr. Poirel noted, that there is some uncertainty about how that will be dealt with by the Committee of Ministers. My understanding is that Russia still has an obligation to implement all of these many judgments. But I think as Mr. Gardner noted in his question, and as Mr. Poirel alluded to in his answer, the question is, how to deal with that in practical terms, and whether it really is practical to be debating these cases, for example, in the Committee of Ministers, when there's so many other cases to be debated and when the Russian Federation isn't there. And from an implementation perspective, hopefully there is an opportunity there to promote the implementation of other cases that might not otherwise have got debated and which are frankly more likely to be implemented. But that doesn't take away from the fact that obviously all these judgments are still legally binding on Russia, and they still have an obligation to, of course, implement them.
Thank you very much, George. And unfortunately, we just at this point run into the end of our allotted time. So once again, apologies to all the attendees whose fascinating questions were unfortunately left on the cutting floor. But we will try to convey those questions over to our panelists and see whether there is possibility of us maybe expanding a little bit on the substance of our webinar. Dear guests, dear panelists, thank you very much for participating in this meeting. It's been a fascinating discussion on a complex topic, which is currently an increasing challenge for two major organizations that have been dealing with the rule of law, human rights and democracy in Europe. And those challenges are, I'm afraid, only going to grow, which in turn encourages a lot of discussion, but also certainly encourages the two organizations to work closely together as they have been in so far and look at opportunities for joint activities and actions that could help the situation improve. With that, I'm going to close today's meetings. I encourage all of you to follow European Implementation Network and DRI in our work on the rule of law and human rights in Europe. And I hope to see you all soon again at another DRI EAN meeting regarding the rule of law in Europe. Once again, dear panelists, thank you very much. And thank you all attendees for tuning into our event.